Good afternoon. I hope you're all enjoying the TPRC traditional Mexican lunch. We try every year a new combination of spices. And apparently what's happening, and this is an inside secret from the TPRC organizing committee, which I'm happy to say it's my last time standing here on its behalf. What you should know is that every year after we visit here, they replace the caterer. Just saying. So anyway, welcome all. It's great to see you all. It's a great opportunity to thank in your presence all of our sponsors that have allowed the development of this conference and its maintenance over the years. I'm not going to speak long. Actually, I'm not going to say anything beyond introducing our keynote speaker for the lunch, my very good friend, Professor Ellen Goodman, a distinguished professor at the Rutgers Law School. In general, Ellen is from Philadelphia, and for us who have roots in Philadelphia, this is a great day as Joel Embiid has just signed a 3-year extension of his maximum contract. So he's with us till the end of the decade. Yeah, go Sixers. So Professor Goodman specializes in information policy law, and her research interests are very wide, and they include smart cities and algorithmic governance and freedom of expression and platform policies and communication architectures and media and advertising law and transparency policy. And she serves as the co-director and co-founder of the Rutgers Institute for Information Policy and Law. I would assume that is one of our competitors, right, of the Institute at Penn State. Professor Goodman recently has completed her service as a senior advisor for Algorithmic Justice at NTIA, the U.S. Department of Commerce. I was clear that nobody was going to come if we don't have some talk about AI, right? So just wanted to make sure we have one. Professor Goodman, or as I call her, Ellen, has served as a senior fellow at the Digital Innovation and Democracy Institute at the German Marshall Fund, and she's received grants from the Knight Foundation, the Ford Foundation, the Geraldine R. Foundation for various projects involving models of platform regulation and transparency, digital public media and democracy, and algorithmic system justice. She has also advised a number of cities on responsible tech deployment, served as distinguished visiting scholar at the FCC, and has held visiting positions at Yale Law School, the University of Pennsylvania's Carey Law School, the Annenberg School of Communication, and the Wharton School, as well as at the London School of Economics. Prior to joining the Rutgers faculty in 2003, Professor Goodman was a partner in the Washington, D.C. law firm of Covington and Burling, and served as of counsel with the firm until 2009. Professor Goodman clerked for Judge Norma Shapiro on the U.S. Federal District Court for the Eastern District of Pennsylvania after graduating from Harvard Law School and Harvard College. She has 3 children, and I know them. I can tell you lots, they're very successful. Anyway, she blogs. She has her own blog at riipl.rutgers.edu and at medium.com, and has written for The Guardian and for the Tech Policy Press and Democracy and for Slate. So it is my great pleasure to invite my great friend, Ellen Goodman.
Thanks, Amit. Great to be here. There are people in this room who I've known for 30 years and or more, and I've always loved TPRC. Okay, so let's get into it. Since generative AI burst on the scene in late 2022, policymakers in every Western capital and in India and in China and in every US state have been anguishing about the coming epistemic storm where ground truth recedes in a haze of synthetic content. NIST and the White House define synthetic content as information that has been, quote, significantly altered or generated by algorithms, including by AI. One of the main responses to come out of these worried capitals is transparency. The EU AI Act and other proposed and adopted interventions would mandate synthetic content detection, labeling, watermarking, and other kinds of technical interventions. Transparency, it is suggested, can mitigate the discursive harms that can result from synthetic content, whether this is deception or more generally confusion about what is real. While I myself have been a big proponent of transparency, I've come to conclude that mandated detection and disclosure policies which default to authenticity are incoherent, possibly counterproductive, and legally vulnerable. This says nothing about the utility of forensics and synthetic content detection research and development outside of legal mandates, all of which is critical work. I'll give a brief overview of sample disclosure policies to give you a sense of what I'm talking about, and then surface some of the risks entailed in defaulting to authenticity in the absence of labels. I'll conclude by suggesting instead that policies adopt a default to distrust and help develop and enable authentication systems as a more coherent, scalable, and legally sound approach. Let's consider the harms of synthetic content. Distinct harms are amenable to different kinds of interventions. The ones I'll be addressing are discourse harms, and in particular, mis and disinformation from digital counterfeits. And these are of concern not just for democracy, but also for the economy and for national security. Two episodes have garnered a lot of attention during this presidential election season. And I'm sure most of you are familiar with both of these. In one, a political operative synthesized Biden's voice in robocalls to tell people not to vote in the primaries. In another, Elon Musk amplified on X a synthetic deepfake of Kamala Harris calling Biden senile. And deepfakes have been used to varying effect in European, Indian, and other elections. These two examples show a range of policy tractability, with the telecoms networks and the robocall example being more amenable to control than pure internet applications. Not all synthetic harms come in the form of deepfakes. In a very interesting paper, Alondra Nelson and Julia Angwin produced evidence of hallucinations from Gen AI outputs providing false information about voting. The discursive harms, like I said, are not just a problem for democracy, but also for national security. Folks worried about destabilizing information warfare, and other parts of the government worried about credibility of data, governmental data releases. And so what this means is there's a powerful governmental constituency interested in mitigating these harms. Then there are dignitary harms. Synthetic content may falsely represent a person in ways that damage her reputation, to wit, the non-consensual intimate imagery of Taylor Swift that was shared tens of millions of times before the platforms removed it, and women and girls are especially vulnerable to this. Another form of dignitary harm comes in the form of digital replicas of human art that has been appropriated in AI-generated look-alike or sound-alike content. This synthetic art, of course, is also a source of economic harm for those artists who lose market share. And there is the economic harm of from scams. So voice cloning in particular has been used for this malicious end. For example, with ransom requests, which my own mother was victimized by, and even sophisticated entities. She is a sophisticated entity, but more sophisticated entities have fallen prey. In one case, a global financial services firm lost $25 million to a voice cloning scam when an employee took instructions from a fake boss. Finally, there are diffuse, long-term, and perhaps even more consequential epistemic harms. When synthetic content is recursively fed back into AI models, there's the risk of model collapse as synthetic production drifts ever farther from ground truth. The accumulated effects of discourse harm can generate distrust in the quality or authority of any information because the information sphere has become polluted. It's important to distinguish these distinct harms because they call for different kinds of interventions and are subject to different legal regimes. Just really briefly, the one I'll be talking about, the main intervention, as I said, is disclosure. There's also defamation law and specialized remedies for very specific kinds of counterfeit information. And here, at least in the US, the remedial space is the most limited because the interventions are likely to be content-based, and the speech is largely protected by the First Amendment, and in other places by analogous free speech regimes. In the case of, so disclosure is not generally an effective remedy for dignitary harms, and instead there's a growing move to ban NCII content. Iowa has done that. Other states have proposed it, and legislation to do that is pending at the federal level. California passed a new liability regime for the deceptive use of likeness in digital replicas, and there's more of that proposed at the federal level. Those kinds of new liability regimes, property rights, of course, also serve to get at some of the economic harms. And then there's consumer protection law, some of which has been, there are proposals to beef it up and to create new enforcement efforts. The epistemic harms are probably the hardest to deal with. They are downstream of the other harms. And so it's really all of the above, and then additional remedies. Some of the interventions proposed for some of the existential AI harms have within scope some of these epistemic harms. For example, independent audits and model transparency interventions are supposed to get at this. So that's the last I'm going to say about anything other than discourse harms. And I lay this out so that we're all clear that I'm not talking about these other kinds of interventions. Okay. So policies to address synthetic content discourse harms encourage or mandate watermarks, metadata or provenance, and or labels, all of which can be machine readable or human readable. Platforms like Meta, YouTube, and TikTok have undertaken to do this voluntarily with the usual spotty enforcement. The inadequacy of private actions has resulted in a flood of legislation or proposed legislation or other policy statements, like the US executive order of last year, which requires the federal government to work on technologies and to implement practices to track provenance and label synthetic content, as well as authenticate content. More on that later. And NIST is taking the lead in addressing synthetic content harms, focusing on disclosure. DOD and Homeland Security have projects developing synthetic content detection and provenance tools because, like I said, they have their own interests in this space. There are lots of proposed federal disclosure bills. They focus on electioneering, deepfakes, and digital replicas, and also just generally on synthetic content writ large. And then some states have passed, and many have proposed laws that require synthetic content labeling. The granddaddy of this is probably California's 2019 bot disclosure law, and then the recently tabled AB 3211 in California, which would have required AI systems to apply provenance data to all synthetic content. The EU AI Act requires AI systems to enable provenance disclosure and detection for synthetic content and to label deepfakes. And the DSA and the Digital Services Act and the UK Online Harms Act encourage platforms to detect and label synthetic content. And China requires generative AI systems to label and watermark synthetic content. These legal and policy instruments generally define synthetic content as content that has been manipulated, altered, that is AI generated, or machine-made. I mentioned NIST definition. The EU AI Act defines it as output that, quote, has been generated or manipulated by an AI system and not a human, end quote, and it excludes common editing technology. Other terms used in legislation are deepfakes or digital replicas. The UK's Ofcom defines deepfakes as, quote, forms of audiovisual content that have been generated or manipulated using AI, which misrepresent someone or something. So there are lots of other definitions in this vein. So it's notable that whereas synthetic content definitions just require alteration of some input, the deepfake definitions turn on misrepresentation or falsity, but there's a wide variety in the degree and materiality of the deception that the laws care about. The kinds of disclosure contemplated by most laws are labels, provenance, and watermarks. Oops. So very briefly, labels are human readable indications of synthetic content that can be affixed upon generation, but more likely are going to be affixed by an intermediary at some point in the distribution chain. Provenance legends, sometimes people talk about them as nutrition labels, are metadata embedded in digital files or stored separately in databases that are cryptographically secured and can have a range of information in them. They can trace the source. They can say something about the creation process, the ownership, and distribution of a piece of content. So that provenance legend is going to answer questions such as who created this content, when, what changes occurred, who owns it, etc. And then watermarks, circled a little watermark down there, which is human readable, but they don't have to be. So they are either visible or invisible perturbations of the digital media files to indicate origin. And most often policymakers use the term to refer to a source identifier for a Gen AI products. Okay, so that's synthetic content. Authenticity is the default condition against which synthetic content is defined, and authenticity is rarely defined. So what is it to be authentic? There's the technical meaning, which according to NIST cybersecurity definitions is this, quote, authenticity is the property of data that originates from its claimed source, so unaltered. But NIST also recognizes a broader normative or socio-technical meaning. Quote, it can also mean being genuine, able to be verified and trusted, or having confidence in the validity of a message or its originator. Social media policies too mix the descriptive and the normative. Authentic connotes real or human-made. Authentic accounts are associated with real people using their real names. Facebook policy polices the, quote, authentic identity of account holders, removing bot or sock puppet accounts. The content monetization policies of TikTok, Meta, YouTube, and the rest equate authenticity with originating with the account holder, so being genuine in some sense. Meta goes more subjective when it says, quote, being a creator means showing the world something relatable and real. In other words, authentic. So the relationship between real and true is unexamined, but as NIST notes, authenticity to many denotes trustworthiness. And this is a problem. Disclosure policies default to authenticity in that unlabeled content is presumptively authentic. In some sense, this is really continuous with how we've thought about text since the advent of the printing press. There is an authoritative text. It is reduced to the addition, and it's authentic. And before then, the text was fluid. The document varied depending on the scribe. And so one wonders whether or not we might be returning to that time. Defaulting to authenticity going forward has some risks. In a sense, I fear that deepfakes are becoming the new fake news that emerged around 2015 and 2016 and was quickly weaponized to accelerate the epistemic uncertainty the term was meant to critique. Let me turn to two concerns about mandatory synthetic content disclosure. There are additional ones that I'm going to put to the side that I'm sure are top of mind for some of you. The most important of these regards their technical vulnerabilities. Labels are easily removed, provenance incomplete or faked, and watermarks can be stripped out. And so to the extent that we're talking about technical solutions, whether we're defaulting to authenticity or defaulting to distrust, there is going to be an arms race against malicious actors. That's a constant. I'm going to focus on the conceptual fragility at the heart of synthetic content definitions and the default to authenticity. Content may be mixed. It may be synthetic and deceptive. It may be synthetic and false, but parody or commentary. It may be authentic and deceptive. This complexity means that definitions are likely to be, as we lawyers say, over-inclusive with false positives, or under-inclusive with false negatives, and also lead to misinterpretation about the meaning of the default, authenticity in this case. To the extent that the obligations fall on intermediaries, there's also the risk of further empowering powerful platforms to make content-based decisions. These problems then create legal fragility in terms of First Amendment and other free speech law. I'm also not going to say too much about privacy concerns, but they sort of are a shadow to all of this, on all of this. The operative definitions of synthetic content as AI made or altered is incoherent. What lawmakers are thinking about is Gen AI output. Even that may not be fully synthetic, but let's just assume it is for argument's sake. So that's on the far right of this little homemade graphic. So now some of that Gen AI content is obviously fanciful, not realistic. So such content may indeed pose dignitary harms or economic harms, but the discourse harms are going to be pretty mild. Then there are AI contributions to authentic content, moving to the left, from a co-pilot or other sort of AI enhancement, all the way to old-fashioned editing, which the EU AI Act seeks to exclude from its definition of synthetic content, but without much precision. It's reasonable to expect that soon, or we'll say soon, most content will have AI contributions. And those of us who teach, I think, are finding it difficult to even define what an AI contribution is when every application offers AI assistance. And then at the far end of the spectrum on the left is the pure authentic content, what is imagined as the faithful capture of ground reality. Let's say the selfie. Yet even selfies can be altered at the source rather than in post-production. This photo on the top places the person with the red pants next to two others they weren't actually next to at the time, using the reimagined function of the new Google Pixel. I think the new iPhone has sort of the same features. So is that synthetic content? Whose responsibility should it be to watermark or otherwise label it? Google's Isaac Reynolds, in talking about this product, contests that it is synthetic. He says it's actually more authentic to the individual's perspective than is ground truth. If you get a disclosure requirement that's too expansive in defining synthetic content, you get false positives. So this Harris campaign photo on the right was altered a little bit, but you can see in comparison to the AP one on the left that it's not materially deceptive. If too much is labeled, you get information overload for consumers, what has been called disclosure blindness. Labels are designed to combat the liar's dividend that Danielle Citron has written about, and tell the public what is actually synthetic, so the liar can't claim that everything is fake. But a labeling regime that is too inclusive can actually grow the liar's dividend. Things that aren't labeled are presumptively authentic, even though they may not be, and things that are synthetic in whole or in part, but not false, are cast in doubt. One way to deal with this is to narrow the definition of actionable synthetic content to that which is deceptive or even intentionally deceptive. So just an example, this is a proposed federal bill, Protect Election from Deceptive AI Act, requires labels on generated inauthentic image, audio, or video that appears authentic. There are lots of other examples like this. We've got FCC folks, so I'll just shout out to their new NPRM, which says which is talking about labels for AI-generated voices that sound like human voices and AI-generated actors that appear to be human actors. So deception is kind of built in. This narrowing helps to limit false positives for sure, perhaps at the expense of more false negatives, but it creates another problem. The regulated parties, sometimes the intermediary distributor, sometimes the Gen AI model, have to assess ex ante what will be deceptive. To the extent that there is a mens rea or intent added to this, it becomes less scalable, more complicated to implement, and resistant to enforcement. To highlight just one wrinkle in making this deceptive content call, a lot of synthetic content is not deceptive because it's obviously parody, fanciful, or puffery. Or is it obvious? Was this Taylor Swift deepfake deceptive? Does the reasonable person know that these riffs on the right of famous portraits that they're commentary? The creator or the distributor have to guess at the reception. And while many may have understood MAGA Taylor to be obviously parodic, she herself said that she was moved by concern over misunderstanding of these memes, that it was time for her to authenticate herself and endorse Harris. These scoping problems become First Amendment problems. In general, a synthetic content labeling requirement is a content-based intervention. So a law that fails to limit synthetic content to deceptive uses is going to be overbroad. In the election law context, the US Supreme Court has applied exacting scrutiny, which basically means that it's going to look very unfavorably on disclosure requirements. I won't bore you with the details of the test. So labeling all synthetic content to address the harm that's been identified, which is mis and disinformation, is going to be vulnerable to claims that it's not sufficiently narrowly tailored to the harm in scope. A law that limits disclosures to deceptive content also has First Amendment problems. While dispelling deception is an acceptable reason, usually for compelling speech, which is what a disclosure requirement is, or a labeling requirement, entities will argue that the standard is too vague. How do they know what's deceptive? And we know from recent courts' recent reception to age-appropriate design laws for the internet, they're skeptical of forcing companies to take actions on the basis of judgments about content harms. At the same time, a law focused on deception could be deemed under-inclusive because it doesn't capture authentic but deceptive content. So the safest approach from a First Amendment perspective is to limit disclosure to where there is intent to materially deceive. And lots of state laws do this, especially in the electioneering context. But this will mean that there are a lot of false negatives, perhaps exacerbating the epistemic doubts about labeled and unlabeled content now that there's a government official regime, and as noted, governmentally sanctioned regime. And as noted, enforcement will be a cumbersome and expensive process. There's also the problem of means and ends, and this goes to the narrow tailoring requirement. If the central discourse harm is the harm of deception, we have to wonder whether limiting coverage to synthetic content is tailored to the goal. Oh, you can't read this. So a lot of authentic content is deceptive because of content or context. So the example here is an unaltered photo of an immigrant with a goose miscaption to suggest that they're eating the goose. Authentic content, deceptive. The obvious target of these interventions is the synthetic deceptive, which is an AI video of an immigrant eating a goose. And lots of synthetic content is also non-deceptive. A group photo using the add me function to complete a scene, like we saw in that Google Pixel photo, again, arguably non-deceptive or trivially deceptive. An alternative to defaulting to authenticity is defaulting to distrust. Let's assume that most content will be at least inflected with synthetic contributions. Might we have to resign ourselves to a world in which, for the near term, as the storm gathers, authenticity cannot be the default? Recall that the AIEO directed the federal government to focus not just on disclosure and synthetic content detection, but also on authentication efforts. This is where I think policy attention needs to be directed. There are private technical efforts such as C2PA's open standard, which creates a provenance record, a sort of chain of title. And the goal here is to verify that the purported source is actually the source and to document alterations or modifications. The product is a narrative rather than a label or a watermark. Other entities are developing other hopefully interoperable methods. And then there are cognate efforts underway to develop digital personhood and digital identity tools, and surely these work streams should intersect. Synthetic content detection and forensics, as I mentioned, are still going to be critical for all kinds of evidence-based work in courts, in scholarship, and in the media. Even in a world that leans heavily on authentication, lots of content that becomes important later to authenticate will not have been authenticated from the start. And so synthetic content detection and other forensics are all we'll have. But in terms of priorities for the use of regulatory power, there's more to be gained by enabling and supporting authentication through the distribution chain than on ex post detection and labeling of synthetic content. One of the benefits of this approach is that it centers the power of human creators instead of AI models and intermediaries. Here's a rough depiction of the content distribution chain. Someone produces authentic content in the upper left. That content is then fed into an AI model that contributes to synthetic output, or the content goes directly through an intermediary or directly to users. The synthetic content disclosure regimes typically burden the AI model or the intermediary, sometimes the content creator. Authentication is the responsibility of the content originator. Originators will have incentives to do this when there are important discursive, governmental, national security, or economic interests at stake. Most content won't be authenticated. And so while authentication doesn't scale, it doesn't need to under conditions of general skepticism. What's needed to make authentication successful are standards and cooperation through the chain. And this is where policy interventions are needed. They're needed to support interoperable standards and mandate that devices used to capture or create media enable authentication. This is what California's AB 3211 did. And also to mandate that intermediaries preserve provenance information where it is provided. One benefit of this approach is that it constrains rather than augments the power of platforms. There are a few proposals out there to do this. The proposed Federal Copied Media Act for digital forgeries would create liability for intermediaries that do not pass through digital provenance. Now, this act is concerned less with discursive harms than it is with some of the dignitary and economic harms of digital forgeries. And this is another benefit of facilitating provenance, is because a lot can be packed into the provenance besides media meaning, also ownership, privacy, and other kinds of credentials. we've traveled a long distance together at TPRC. And so I know that some of these interventions from the past are dear to the hearts of many. The approach I'm suggesting is not new to tech. The DMCA penalizes interference with encryption. The 1996 Telecom Act arose, the VCHIP provisions arose from a similar situation where policymakers wanted things labeled, but they didn't think they could force them. So they adopted a requirement that if content creators used standardized labels, distributors would have to enable them. And then finally, a more recent example, the Software Bill of Materials, which is a legend, like the provenance legend, sort of took off because the US used its procurement power to require software vendors to provide a software bill of materials and then help to standardize it while still leaving it nominally voluntary. It's understandable that policy reaches for synthetic content labels because they seem to rhyme with familiar disclosures from analog media, such as the sponsorship ID in broadcasting ads. But actually, the I approve this message on broadcast electioneering ads works differently. It defaults to distrust. It lifts up messages that are actually attributable to the candidate. And I think authentication is closer to that. The equivalent of the label is the authentication process and the digital manifest. And that's what I think policy should support. Thanks. And we have question time. Questions. Right. So anonymity is a sort of problem for all of the personhood authentication, all of the authentication family suite of tools. And there is work, and that's what I meant when I said these streams are going to have to intersect, that all the work that's being done on digital authentication generally and proof of personhood are trying to solve this problem of having pseudonymous and anonymous identifiers. And I think the main thing, and so, if you want to make sure it was a person who originated the content, that personhood would have to be authenticated as well, but not necessarily with their real name. Okay, so first of all, there's nothing that requires authentication here. And so, does the Washington Post want to authenticate its content? I mean, we've lived in a world where all of the main media organizations have a strong interest in authenticating content that it's coming from them, and they have journalistic norms and standards which they say authenticate their content. Doesn't mean that they don't keep sources secret. So there is no mandatory authentication here. The only mandatory part is that when creators choose to authenticate, it gets passed through. I think that lives completely harmoniously with your suggestion of empowering users to have filters and to use AI. In fact, it actually enhances that ability, because if the filter you want to use is, I only want to see authenticated content, you'll be able to do that. If you don't care about authentication, you won't use that filter. Thanks.
Wait, no, you can't go because it's my honor to present you with a TPRC chocolate. There you go. Thank you so much. Okay, any announcements? Panels begin in 10 minutes. Okay, there you go.